Welcome to ChamberLIVE for today. We're looking at testing times for your contracts. The views expressed in this webinar don't necessarily represent the views of the East Lancs Chamber of Commerce, and all facts were believed to be correct at the time of recording, which is the 13th of May 2020. Time to introduce our guest speakers, and we've got a record-breaking 4 speakers today, all of whom are from law firm Forbes. Forbes have got offices across the north, but their roots are firmly here in Lancashire. They offer a full range of legal services to individuals, commercial clients, a number of specialist sectors where they excel nationally. Our speakers, Michael Chambers, we're going to hear from first. Michael's a partner, also head of the firm's dispute resolution team. He specialises in commercial dispute resolution, dealing with a broad range of litigation arising from contractual disputes, shareholder and hospital issues, along with personal and corporate insolvency and property litigation. We'll also hear from Stephen McCardle. Stephen's a partner in the dispute resolution team and an experienced commercial litigator. He specialises in commercial litigation as well as property litigation. John Pickervance is a partner and head of commercial at Forbes. John specialises in a range of commercial matters such as contracts and intellectual property. He heads up Forbes' manufacturing and engineering sector group. He works for clients across a range of sectors and trading on both a national and an international basis. And last but by no means least, Sadie Butler. Sadie is the head of Forbes Collect, which is part of the dispute resolution department. You don't want to get on the wrong side of Forbes Collect. Sadie provides straightforward advice to businesses and individuals on the best way of recovering their outstanding commercial invoices. That's quite a team that we've got assembled, so time to meet them. And I'll hand over now, first of all, to Michael.
Morning, Simon. Thanks very much for the introduction there. Welcome everyone to our talk this morning on testing times for your contracts. As Simon said, you'll be hearing from 4 of us this morning from Forbes, each covering slightly different aspects of your contractual relationships with your customers and clients. It's more important than ever at the moment to protect yourself in terms of contractual obligations and, more importantly, getting paid for goods and services that are supplied out of those contracts. I'll hand straight over to my colleague Stephen, who is going to talk to you about force majeure and frustration of contracts. Then we'll hear from John Pickervance, who will be talking to you about boilerplate clauses and their enforceability. I'll be talking to you a little bit about relationships with your customers and clients at this time and how to manage anybody who is a slow payer. And Sadie will finish off by talking to you a little bit about what happens when people continue not to pay for goods and services. I'll hand you over to Stephen now. Thank you.
Good morning, everyone. As Michael's just said, my name's Stephen McCardle. I'm a commercial litigation solicitor and a partner at Forbes. And I'm going to be touching on and focusing in on a couple of important aspects of your commercial contracts and the effect that COVID-19 has on those contracts. And in particular, I wanted just to look at the disruption caused by the lockdown on commercial contracts and how you can interpret those contracts to your benefit. Then we'll move on to what could happen if you don't have any clauses within your contract and where you stand there, and I'll look at the doctrine of frustration. And finally, I'm going to have a look at what to do in terms of trying to resolve any disputes or issues that you have. I think we'd be hard-pressed to find anyone here who wouldn't be concerned about the effect of COVID-19 on the business, from professional services, manufacturing, leisure, hospitality, retail and charities. Doesn't really matter about the size of the organisation. Everyone is and has been and probably continues to be affected. The COVID-19 outbreak has imposed unprecedented restrictions on the movement of people, which has resulted in a significant knock-on effect on business. It was reported last week, I think, that the government is now paying the wages of about 25% of the workforce, which really is quite a remarkable statistic. Businesses have temporarily closed, of course, operations have been suspended, and supply chains have been severely disrupted. And of course, a lot of events have been cancelled. And so when we look at the bedrock of any business, whether it is its relationship with customers, suppliers, delivery or logistics, or just the supply of its goods and services, then contract and contract law is the key issue. And so I'd say that any business really at the moment should be carefully considering the legal issues arising out of their contracts that might be affected by COVID-19. And probably the most common issue that clients have asked me about over the last month or so is to do with the effects of COVID-19 on their obligations in their contracts, and specifically, are they still responsible under those contracts despite the lockdown? As the first point I'd make on that is that contracts under English law are absolute, and by that I mean that once the formation of the contract has occurred, the parties must perform and observe their contractual obligations in full. That's the starting point. Second, there's no underlying common law principle or automatic right which simply enables the parties to suspend a contract or certain obligations in it unless the contract itself specifically says so. And this principle also applies, of course, to anyone affected by COVID-19 and the lockdown. And thirdly, a failure to perform a contractual obligation might render that party in breach and open themselves up to litigation. And a breach of contract would typically give rise to a claim for damages, which is a sum of money to cover losses that have been suffered, or alternatively a claim for an order to compel a party to perform its contractual obligations. So if you think that you can't comply with one of your contractual obligations as a result of the COVID-19 lockdown, then the first task really is to carefully check your contract to see if you've got, first of all, a force majeure clause. It's one of those phrases that's being used quite a lot at the moment. So what is a force majeure clause? Well, it's essentially an emergency contractual provision which alters the usual obligations under the contract, and it also acts as a limit on liability if certain extraordinary circumstances or events occur. And the applicability of a force majeure clause and how it protects a non-performing party will depend on how it's drafted. And it's a common misconception that just because there is a force majeure clause, that this will automatically absolve the party from all of its obligations, whereas that is absolutely not the case. However, if a clause does apply validly, then typically parties can benefit from being excused from non-performance of the contractual obligation, either in whole or in part. It can protect a non-performing party from a claim in breach of contract. It can provide for an extension of time or impose a suspension of performance for a period of time. Or in some instances, it can allow for the contract to be cancelled. Now, the burden of proving that the circumstances have been met and that the clause applies to a particular situation rests with the party seeking to rely on it. And so given how important a force majeure clause could be to a business affected by COVID-19 and the protection that it might afford, it's therefore important that the following steps are taken to see if that clause applies. So firstly, consider the clause itself. Identify whether the force majeure event has occurred, and these might be defined within it, such as clauses might cite pandemics or epidemics, in which case COVID-19 is likely to apply, of course. Some force majeure clauses might refer to acts of government or orders made by government, and whether these apply to the present circumstances really will depend on whether the government has issued a direct order or just advice. Clauses might refer to the events outside the party's control. And again, it's likely that COVID-19 will apply because clearly no one could foresee this or can control what's happened. My own view is that a court is likely to deem COVID-19 a force majeure event in many instances. But as I said before, it's really important that you check the specific wording of your contract and the force majeure clause itself. So the next thing to do, once you've established that you have a valid clause and an event has happened, is demonstrate causation. And so in other words, that the force majeure event has affected the performance of the contractual obligation and evidence that it's the true cause of the non-compliance. And the clause will set out the extent of the effect needed for that clause to help you. But typically, you would have to establish that the event, so in this case, say for COVID-19, has either prevented the contract from being performed, either legally or physically. It's hindered or disrupted the performance of the contract, or in some instances, it's merely delayed the performance of the contract. And so you'll need to be shown as well, and this is a key point, that irrespective of the effect on the performance, that you have tried to comply with your contractual obligations and also mitigated any effects that the event has had. And finally, it's common for force majeure clauses to have very specific notice requirements in them, which require the relying party to serve a specific notice on the other party. And so to get the benefit of that clause, it is really key to comply with those procedural requirements. But what happens if you don't have a force majeure clause and you can't benefit from those contractual provisions in the circumstances? Well, in those circumstances, you might be able to rely on what's known as the doctrine of frustration. And this provides that a party is completely discharged from its contractual obligations if there is a change in the circumstances which are unexpected, beyond the control of the parties, and makes performance of the contract physically or commercially impossible, or would render the performance radically different to what was intended by the parties when they entered into the contract. And there isn't a requirement to have a frustration clause in your contract. It is a common law principle. And just by way of an example, a frustrating event might include perhaps a law banning all public gatherings being brought in after a contract was agreed and signed for the staging of a music concert, for example. So although there are similarities between the contractual force majeure provision and the common law frustration doctrine, there are also some key differences. If a contract is frustrated, it automatically ends, and so the courts are not that quick to rule that frustration has taken place, where one party is arguing that. And so the legal bar is also set quite high in terms of being able to prove it, as compared to simply referring to your contract and meeting the tests set out in your contractual clause for force majeure. And the Law Reform Frustrated Contracts Act 1943 provides that in frustrated contracts, monies paid by one party to the other might be recoverable, and that future obligations to pay money might not be due. And similarly, payments for part performance might be due. And that is obviously quite different to how force majeure works and the continuing obligations under the contract itself. And finally, on the issue of frustration, if it does apply, then of course, I've said the contract automatically ends. And of course, for many businesses, that's not going to be a commercially attractive option for the parties, but nevertheless, it should be considered. And so the third area I'm just going to touch on now is negotiation and alternative dispute resolution. And many businesses affected by COVID-19 will want to prioritise the preservation of the commercial relationship that they have, even if it's been disrupted, and protect future business, which is going to be so important after the lockdown is eventually lifted. And therefore, focus should also be on maintaining the relationship and negotiating any disputes where possible. And therefore, aside from assessing the legal position, be it in your contract or in common law, and checking your clauses which might assist, it's also advisable to consider negotiating with your other party to see if a mutually agreeable solution can be reached. And if you agree in principle to vary the contract to take account of the effect and the disruption of the COVID-19 on those obligations, then it's also important to ensure that any variation is properly recorded in writing, and should always consider getting legal advice on that by asking a solicitor to help. A business that suffers a loss under a contract as a result of disruption caused by the lockdown should also carefully consider any insurance policies that it might have to ascertain whether or not cover is in place. But it is common with insurance policies that there are strict conditions on notification of claims. And this means that it's really critical that you identify potential claims early and tell your insurers in accordance with the policy. And from my perspective, from a litigator's view, unfortunately, one of the other side effects of the present lockdown is that the operation of the courts, the court system, has been disrupted. A lot of courts have been closed, some are partially open, trials and hearings have been adjourned. And the result of all of that is that cases that are in the courts at the moment are taking longer to reach a resolution. So where a dispute arises over the performance of a contract and there are allegations of breach of contract, or if there's a serious disagreement over the applicability of a force majeure clause, for example, then the parties should look to enter into without prejudice negotiations to try and resolve the dispute and avoid court if you can help it. One of the most effective forms of without prejudice negotiation is mediation, and this is especially so when the relationship between the contracting parties is particularly contentious, making discussion or negotiation difficult. Mediation is a form of assisted settlement where the parties jointly instruct an independent mediator to help broker a compromise and settle the dispute. And although mediations usually take place in person, face-to-face, they have recently been quickly adapted to the present situation and now work virtually, where the mediator and the parties adopt video conferencing platforms to mediate. And again, I would always advise that the party involved in mediation does consider having legal representation to ensure the best possible result is achieved. And so, as you can see on the screen, my top 5 tips from a litigator in the present situation. Firstly, get legal advice on your contract to establish what clauses might assist you. 2, always communicate with the parties early to see what might be accommodated in order to preserve the commercial relationship, and also check your insurance policies. 3, if a dispute does arise, always consider without prejudice negotiation, such as mediation, to avoid court proceedings if possible. And 4, ensure your contracts are future-proof, have them reviewed now and ensure that they are fit for purpose. And 5, if a resolution to your contract dispute isn't possible, then make sure you take legal advice early and look to enforce that contract at court without delay. So that's all from me for the moment. I'd be happy to take questions at the end or by email following the webinar, and I'll hand you over to my colleague, John Pickervance, who's going to talk about contracts in a bit more detail.
Okay, thanks very much, Stephen. For those of you that don't know me, my name is John Pickervance, partner at Forbes and head of the commercial team. Within the commercial department, we look at drafting contracts on a daily basis. And what I'm going to do today is go into, in a bit more detail, some of the other types of obligations or provisions within contracts that you need to look at, in addition, I suppose, to force majeure. The 5 main areas that we're going to cover here are performance obligations, delivery and title in the context of providing goods, term and termination, very importantly, liability and indemnity, which is what most issues come down to in a contract. And then finally, we're going to touch upon intellectual property rights. I think the overriding and underlying thing that you all need to remember is that you really shouldn't make any assumptions with regards to the presence of COVID-19 and the effects that it's had upon you. Even if it's very difficult to perform a contract, it's important that you check the small print and ensure that the contract that you've got is fit for the purpose that you need to rely upon it for. Okay, so looking at those performance obligations in the first instance, and as I say, Stephen's touched upon force majeure, and I'll just mention it ever so slightly at the beginning here. So force majeure is great if it works. So you need to remember that there has to be an element of causation between force majeure events and the presence of that and the effect that it has on your ability to perform the contract. So there needs to be that causal link. So check the contract, first of all, that epidemics and pandemics are covered. It's very likely to be the case, but it's just worth checking that nonetheless. And then secondly, you need to be able to prove that the presence of that is preventing you from performing your obligations. So the rest of this slide we'll look at in the context of there not being a force majeure clause, or if there is a force majeure clause, you're unable to rely upon it. So first of all, let's look at what you actually have to perform in the contract. Now, Stephen mentioned earlier on that once a contract is formed in English law, it's absolute. And that is the case unless certain things are specifically carved out, which I'll come on to. But looking at those absolute obligations, how do we know when that's the case? Well, typically speaking, you'll see a clause like this one. So it would begin with party A shall. Now, if it says shall, and then it goes straight into the obligation, then that means it's an absolute obligation and it has to be performed. So this would generally relate to a party's primary obligations under a contract. In the case of a customer, it'll be party A shall make the payment, for example, or for the supplier, party A shall provide the goods or deliver the services. So that's nice and clear. But what it does mean is if you can't rely upon force majeure, then no matter how difficult or immoral or unreasonable it may be to perform that obligation, you still have to perform it. So short of an absolute obligation, we have the obligation to use certain endeavours in order to comply with those obligations. So tantamount to an absolute obligation is the requirement to use best endeavours. Now that means that you have to use everything within your power and ability and knowledge in order to provide the goods or the services or perform the applicable obligation under that contract. It's a very, very difficult level of burden to reach. And it can be very, very unreasonable in some circumstances. But the word unreasonable is quite important here because you can't rely upon something being unreasonable to get out of using your best endeavours. So we tend to say never, never best endeavour when we're drafting a contract, which is about as much fun as we get in contract law. In terms of the next levels of endeavour that you have to use, you've got all reasonable and the obligation to use your reasonable endeavours. Now, this is, as it states and as it sounds, a reasonable threshold. So if you are being required to do something to perform an obligation which is unreasonable in light of the current situation we face, then it's likely that you can exonerate yourself for performing that obligation. So do just check what the contract states in terms of what you do and don't have to do. Ultimately, the decision on whether or not to comply with a contractual clause is likely to boil down to what the consequences of that failure are. So we will point you, secondly, to the liability clauses, which are likely to follow. And we'll come on to that in a bit more detail. But do always take a commercial approach to a contract and an obligation to do something. And at that stage, and as Stephen said before, do pick up the phone or write an email to your counterparty and see if you can negotiate a sensible way around it. Looking now at performance warranties, it may be that you're able to comply with your obligations, but what it may not be, dependent on what the contract states, is possible to provide those obligations in line with a certain warranty. Now, a warranty in this context is a contractual promise, and it's a contractual promise that something will be done in a certain way or maybe by a certain time. So you need to make sure that you can still comply with your performance warranties, even if you're able to comply, but maybe in a delayed fashion or in a weaker fashion, for example. Okay. So looking at the performance of a contract in the context of goods, and you've delivered your goods to a customer, but possibly in light of certain cash flow issues that businesses are experiencing at the moment, you're struggling to get paid. Well, the default position in relation to the transfer of title in goods or ownership of those goods, in layman's terms, is that as soon as the customer receives physical possession of those goods, it will own them. Unless, of course, there is what we call a retention of title clause within the contract. Now, a retention of title clause in its very simplest form will state that goods, ownership of goods or title in goods will remain with the seller until such time as they've been paid for them in full. But a better clause will go a little bit further to provide some additional remedies, because by itself, that doesn't give you a great deal of comfort if, for example, you can't go and get those goods back if you don't have the right to enter someone's premises to recover them, for example. So if that's required, then do make sure that is covered in the contract. Also, you may be able to trigger the ability to do that, or try and recover certain monies or losses that you may suffer as a result of non-payment in the event of an insolvency, for example. So it might not be that the payment is overdue yet, but the customer has gone insolvent, in which case you want to make sure that you cover those goods. Alternatively, if you're aware that your customer is selling on the goods to an ultimate end user, then maybe the clause goes a bit further and states that any monies which they hold are to be held on trust for you until such time as you've been paid in full. So check your retention of title provisions and make sure you've got them, but that they work for you as well. Right, so turning now to term of the contract and termination of the contract in the context of a failure to perform certain obligations. So we've looked at how difficult it may be to perform certain obligations, but now we need to know what we can do as the other party if those are failed to be performed. So it's really the circumstances relating to the non-performance that are going to dictate what you can do. Don't merely assume that because somebody hasn't performed the contracts that you can just simply terminate or terminate immediately. Check the contract. So first of all, we've got what we call termination for cause. Now, this is essentially where there's been a breach of contract. So look at the termination clause. Check, first of all, whether you must give the other party the ability to remedy that breach, whether they've got a certain time period within which to remedy it, or whether you've actually got to notify them of the breach before you can exercise your rights to terminate. So make sure that that's nice and clear. If they are able to point to force majeure and that they haven't been able to perform their obligations due to that force majeure event, then it's likely that a well-drafted force majeure clause will go a bit further to say that it will have to be a certain period of time that elapses before you can then exercise the right to terminate. It's typically somewhere between 2 and 3 months that you'll see in a contract, rather than simply the immediate right to terminate a contract. So do make sure that you check your force majeure provisions for termination rights as well. And ultimately, looking at the consequences of termination is also likely to depend on the trigger event. So if a contract has been terminated under the force majeure clause or due to the force majeure event, legitimately under the terms of the contract, it's not likely to be the case that either party will suffer a financial liability as a result of that. If, however, you can't rely on force majeure, you've breached the contract and the other party is terminated, then chances are that you're going to suffer a financial liability. Okay. So ultimately, what it boils down to is your potential exposure under the contract, and a liability and indemnity clause, or maybe just a liability clause by itself, is typically dealt with in 3 or 4 different ways. And I'll walk you through those 3 or 4 different sections or ways now. So the first thing we tend to see in a liability clause is an exception. So this will state what it's not possible for either party to limit their liability for under a contract, or to exclude their liability for under a contract. Now this typically is things like death, personal injury, or anything that results from fraud or fraudulent misrepresentation that one party is committed. So those are set out in statute that you cannot limit or exclude your liability for those events. Those aside, we then look at the exclusions and limits on our liability. So first of all, exclusions. Now, what this means is you're completely excluding certain types of liability from being suffered as a result of a breach of contract. So this may be loss of profit caused to the other party, for example. It may be loss of business, loss of contract. It may be damage to someone's goodwill and reputation that you've caused because they're not able to perform their onward obligations to their customers, for example. You can completely exclude those under the contract if the clause is drafted properly. So going forward, you know that if there's a risk that you're not going to be able to perform your contractual obligations due to the current circumstances, make sure that you've got some good exclusions in there so that you know that your exposure is relatively well limited. Looking at limitations now, secondly, for all the things which you can't exclude, you can then look to limit or cap your liability for. So we're talking now about the direct loss which the other party suffers on the back of your breach, and the direct loss that you haven't excluded in certain shapes or form. What we tend to see sometimes is a limit which aligns with a party's insurance cover. Now that's all well and good if your insurance covers you for the certain types of breach which you've caused. Typically that will be the case, but in certain circumstances, and particularly in the case of COVID at the moment, insurers are washing their hands of these potential issues. So if you've got a high level of limit in your contract to align with your insurance and you're not covered, then all of a sudden you're potentially open to a uninsured liability of multiple millions of pounds. In which case you potentially want to have a secondary limit which states what your uninsured limit is. And even better, you just want the overall limit to be set at a relatively low level anyway. And what we tend to see is something which aligns with the value of the contract. So it may be that your ultimate remedy is to receive a refund, or as a supplier who's failed to perform the goods, your maximum exposure is to give a refund of what you've been paid, which is quite reasonable in the case of a COVID breach. Looking now at being the party on the receiving end of the breach and the party that suffered a liability, normally we have to go through the steps of proving that a breach of contract has been committed, then proving that that breach has caused a loss, and then quantifying the loss that we've suffered as well, which can be quite a difficult process to follow, an expensive one. Even better is if you've got an indemnity within the contract, which simply states that the occurrence of event A is something that may trigger a loss. And you don't then have to prove the causal link between the two, provided you can show that the breach has taken place or that the event has taken place and that you've suffered a loss. You can then make a demand for that loss under an indemnity clause. So really, really effective remedy. So do make sure that your contracts contain indemnities if you're looking to recover. Okay. Finally, just touching briefly upon intellectual property rights. If you're perhaps dealing in the digital sphere, creating intellectual property rights or having intellectual property rights created for you, then it's often that as the customer, you won't receive those intellectual property rights until you've paid for them in full. So do make sure that you can still effectively make use of those intellectual property rights if there are any delays in the contract, for example, or if the other party goes insolvent, you need to make sure that you can still get hold of those intellectual property rights, even if you haven't paid for them. But do make sure that your contracts are set up so that there's something in writing to effectively transfer that over to you as the customer, else you'll be in a difficult position moving forwards. Also, we were seeing at the moment that a lot of businesses are turning their hands to different types of goods and services. So some, for example, that our clients of ours have started manufacturing hand sanitizer, and maybe you need to know the specifications or formulas that you've been given as a manufacturer aren't taken from somewhere else or aren't going to cause anyone any harm. So make sure that you've got effective warranties within your contracts as to the legitimacy and non-infringement of those intellectual property rights. And separately, outside of contract law, we're being asked by clients at the moment whether the epidemic, the pandemic, is having a consequence on your ability to register intellectual property. It's not. It's still possible to register. The Intellectual Property Office are still open, but it is causing some delays at the moment. So if you've got that in mind, make sure that you start things sooner rather than later. Okay, thank you very much.
Thanks, John. We've heard from John and Stephen this morning about what you can do to protect yourself in terms of having your contracts with the correct clauses in there and how to rely upon them. What I'm going to talk to you about briefly is the effects of slow payers and late payments to your business can have once you've entered into those contracts for the supply of goods and services. Some things to think about are if your customers and clients are late in paying you, does that impact on your ability to pay others? Are you using funds that were set aside for another purpose to protect your own cash flow? It can also have an impact on your growth as a business. And looking at reports carried out last year, it can have a serious impact on time spent in pursuing outstanding money owed to you. A report carried out into SMEs last year said that there was some 56.4 million hours spent looking into overdue payments, and over half of this time was spent outside of normal office hours. So the impact there is really quite serious, and you need to be able to protect yourself, which is more important now than ever, as when we come out the other side of the pandemic, businesses need to be as cash fit as possible. So some things you can do in order to protect yourself. When you're looking at entering into a new agreement, you've got your contract there with the clauses as outlined by John before. Who is it that you're entering into that contract with? There's some things that you may want to consider. You may want to look into the background of your potential client or customer by obtaining references, looking at some sort of application process. You also need to think about what the legal entity of your customer or client is, whether it's a sole trader, partnership, or limited company. If you're dealing with a limited company, you may want to consider personal guarantees from directors, and, as I say, carry out credit checks. The other thing to be mindful of is that given the amount of time that you could spend in pursuing outstanding payments owed to you, if you're at all unsure, then don't be afraid to say no. If you think in the long run it's going to be troublesome for you. John dealt with this in greater detail than I will go into now, but one of the things that will help you is that the agreement between you and your customer or client is clear, and the scope of the works to be done, goods to be supplied or services is clear. The more that's agreed in writing at the outset, it narrows the scope for disagreement at a later date. Within your agreement, John touched upon things like retention of title and ways that you can protect yourself. You also might want to look at penalties that you can include for late payments, and also to encourage people to pay on time or even early. You can incentivise this as well. So offer discounts if people come in with payments before they're due. If works are going to be ongoing, it's sometimes a good idea to get payments on account of work or in advance of works being carried out. If it's to be done on a retainer or repeat basis, this can quite often work to, again, limit your exposure. When looking at credit control, there are a number of ways which you can help yourself in terms of protecting your ability to recover money. One way is to ensure that creditors are able to pay you in a number of ways. So payment by telephone, cheque, backs or online payments are helpful. Keep deadlines for payments to a minimum as well. If you're able to get a short turnaround time on those payments, then there is a better chance of recovery of them. Consider the terms of your agreement and whether you're able to stop supplying the goods or services there in order to minimise any risk. Look at your own credit control policy, and if you have one in place, make sure that all the staff that work for you are aware of it, and make sure that they adhere to it. If you don't adhere to your own policies, then it's less likely that your debtors will. If you're dealing with a number of invoices, you might want to look at invoice finance or credit insurance as well, if that would assist at the moment. So if there are invoices still outstanding, there are further steps you can take if your internal credit control method hasn't worked. I will hand over to my colleague Sadie now, and she will take you through in a bit more detail what's involved in that process.
Okay, thanks Michael. So as Michael mentioned, I'm just going to talk through what the debt recovery process looks like, and what happens basically once you transfer a file over to any solicitors or agents. Obviously at the minute you might be experiencing a higher number of outstanding debts, so it's just a bit of a brief overview for you. So once you give your initial instructions to a debt recovery agency or a solicitor, they should be carrying out the relevant searches on that debtor. It looks slightly different for both individuals and companies. So for individuals, they should be checking the individual insolvency register. This will show a name match and a last known address match on there. It's just checking for individual voluntary arrangements, any debt relief orders, if that debtor is bankrupt, and on that database it shows that if they have been on there within the past 3 years as well, so it gives you a bit of an idea on the financial status of the debtor. In terms of companies, we would be looking at Companies House, checking if the company is active, if there's any active proposals to strike them off. We also look at if their accounts are up to date and their confirmation statements are up to date, and lastly we'd be looking at their registered office address. You may have a trading address for that company, which is fine, and our letters can all go to that trading address, but we also send our letters to the registered office, as that is where all post is deemed served to the debtor. And it could well be an accounts address too, and again, post will still go there. In terms of what should be provided upon an initial instruction for debt recovery services, any agreements, client care letters, anything that you may have in place with the debtor, they will need a copy of. Any invoices, statements will do as well. They'll need to be provided with any payments that they may have made toward, any part payments they may have made towards the outstanding amount. And lastly, any relevant info about the debtor is needed, so that's address, names, telephone numbers, email addresses if you have them, and an interesting one would be their employment status if it's an individual, if they're employed, self-employed or unemployed, and if you're really good, an employer name would be fantastic, and I'll talk about that later when we come to enforcement. So as you can see, the first step would be to send the debtor something called an LBA. That stands for letter before action. It does what it says on the tin really. It's the letter that we send threatening them of any further action that we're going to take. Initially it'll outline that you are now being represented by that debt recovery agency or solicitor, and it will detail the outstanding invoice or invoices, and mention any further information in regards to that debt. Underneath that, they'll be informed of any interest and late payment charges that they have incurred. In terms of these charges, subject to any other agreements being in place, we would go off the County Court rate and the Late Payment and Commercial Debts Act. Sometimes clients do have in place certain agreements and terms and administration charges for late payments. But if you don't have that, the County Court rate for interest will apply. For interest, it's different for individuals and companies. So for individuals, the County Court rate is set at 8%, so we could charge interest from the date that that invoice fell due to the date that we're sending that LBA, and it'd be an 8% rate, and the daily rate again would accrue at 8%. In terms of companies, it's slightly different. They are 8% above the Bank of England base rate. So Bank of England base rate for quite a while has been at 0.75%, but as you may have noticed, it fell in early March, on the 10th of March, from 0.75% to 0.25%, and then it's fallen again on the 19th of March to 0.1%. So it's at an all-time low at the moment. So that interest is charged from the date that the invoice fell due. So if your invoice fell due in December last year, it would be an 8.75%. But if it fell due after the base rate dropped in March, it would be 8.1%. In terms of late payment compensation, this is something that we're able to claim on business-to-business debts. So it does apply to sole traders because they are classed as a business. It's something that clients don't really know about or aren't aware that they're able to claim. So it's quite a good way to incur further charges on the debt, and also it does contribute to any fees that you might be paying to any solicitors or agencies. The late payment compensation is a 3-tiered process, and it's charged per invoice. So any invoices under £1,000, you get £40 per invoice. Any invoices between £1,000 and £10,000, you get £70 per invoice. And any invoices over £10,000, you get £100 per invoice. So that will be your interest and your late payment compensation detailed within your letter before action. Underneath detailing to the debtor the charges that have been incurred, there will be payment methods and how the debtor is able to pay. And as Michael mentioned before, the more payment methods that you offer the debtor, the easier it will be to collect that debt, and then it leaves them with little excuses on why they aren't able to make payment. They'll then be given a deadline of when to make payment by. Again, it's slightly different here for individuals and companies. For individuals and sole traders, there's a pre-action protocol for debts, and that's changed significantly in October 2017. It just kind of puts the individuals and sole traders in a little bit of a bubble, the more protected, and we have to give them a little bit more time and more information to the debt. So individuals and sole traders have to have 30 days to respond to our LBA. They also have to have 3 attachments to our LBA, and that is an information sheet, a reply form, and a financial statement. These attachments just give them a bit of a prompt. The reply form especially gives them a kind of question. They ask them questions, and then they can have answers and reply to us in regards to the LBA. Financial statement gives us an insight into what their finances are at the moment, and the information sheet gives them details of anywhere they can get debt advice if they are struggling. It doesn't apply to companies, so at Forbes, in the debt recovery team, we give companies a standard 14 days because we feel this is enough time to send enough chasers in the interim period, and also enough time for the company to, one, receive the letter, make any representations if they have any, and also make payment. We can lower that to 7 days. It's entirely up to you, but again, you want to give them a reasonable amount of time to enable them to respond. Lastly, on that letter before action, the last paragraph should detail the further action that you will be taking if payment or a response isn't received. There should always be a counter-court claim threatened on there, because that is the further action that you can take on any debt, issuing a counter-court claim in the hope of securing a counter-court judgment against the debtor for your debt. However, on certain matters we are able to threaten insolvency proceedings, so a winding up proceeding for a company and a bankruptcy proceeding for an individual. There are certain thresholds for that. So for a company, if the debt is over £750, the threat of insolvency can be put on there, because we are able to pursue a winding up petition should you want to. And for individuals, it's higher. It's if the debt is over £5,000, we're able to threaten a bankruptcy petition on there. After the LBA has been sent, it's not necessarily compulsory to send further chases and a final demand and things like that. So some agencies and solicitors might not do it. But talking from the Forbes Collect experience, we send out a chaser in an interim period from the LBA to in the deadline that we give them, and also we send a final demand on the deadline. We find that debtors pay at all different points, whether it's from the LBA, the chase, or the final demand. As the increased amount of pressure on the debtor, the more likely you are to get paid. So once you have taken all of these steps and you find yourself in a position where you've still not been paid, they may have ignored it, or they may have made representations and then nothing further, you're then looking at issuing a county court claim, as this is the most common route that we pursue for debtors. So in terms of issuing a county court claim, this is just a bit of an overview of what happens in that process. So there is a court fee payable on any claim that you issue. Any issuing attracts a court fee, and the court fee does increase with the amount of claim that you are making. This is obviously disbursement and would be payable by you, but it is added onto the claim and will be recoverable if you are successful in your claim. So the solicitors or the agency should draft the claim form and particulars on your behalf, and these will be sent either by first class post, or it can be done online as well. Once the court have processed your claim, the debtor will receive a notice of issue. They'll receive a copy of our claim form, and they'll also receive a response pack. We, as the claimant solicitor, will receive the notice of issue to let us know that the court has dealt with our claim, the date it was issued, and the date that it's deemed served. Now, from that date that the claim is deemed served, the defendant has 14 days to either respond or make payment of that debt. There are different routes that the debtor can take at this point. They can defend the claim if they want to. As a claimant solicitor at this point, we would advise you whether it's worth seeking advice from a specialist dispute resolution solicitor, whether it's worth taking it on yourself, or whether it's worth maybe trying to come to a settlement outside of court with the defendant. They can not respond to your claim and ignore it. They can make part payment of your claim, and if they do, we're able to take your instructions on whether you'd like to secure judgment on the remaining amount, or if you're happy with the part payment they've made, or they can pay in full, and obviously the claim will be discontinued and the matter obviously will be finished. If they choose not to respond and to ignore all of the correspondence from the court, on the 15th day, so that is after the 14th day, 14 days has expired, we're able to file for default judgment on your behalf. Any interest, again, from the date of issue to the date of securing default judgment will be accrued as well. A county court judgment will stay on their credit file for 6 years. It significantly impacts their ability to gain credit, and also will have an impact on their financial status. Once you have that county court judgment against a debtor, your debt is then secured. But you do have further options should you wish to take them, and these are obviously your enforcement options. So here I've labelled 4 different options that you can take. So the first one is bailiffs. This is the most common route that we in Forbes Collect take for clients. If the debt is under £600 or the judgment is under £600, we would instruct the county court bailiffs, and if it's over £600, the higher court enforcement officers are instructed. They would basically go and visit the defendant's address, whether that's commercial or residential, and they want to recover goods for the same amount as the debt, or some of the debt, and then basically they apply as much pressure as possible by visiting their address to force payment from the debtor. The second one is a charging order. So if we know, or you know as a client, that that debtor has a property in their name, we can apply to secure a charge against that property. Again, it can be a residential or a commercial property, provided that the debtor does own it. This means that if they ever come to sell that property, they would have to discharge your debt, as it is a secured charge against their property. The next one is an attachment of earnings order. The court would inevitably grant an order that the debtor's employer should deduct a percentage of their wage, and it should be given to you as the creditor. But on this, we have to know the employer, we have to know who they're employed by. Again, if they're self-employed, you can't get an attachment of earnings order. And also, we have to consider minimum wage here, as we can't go below the threshold. We can't take an amount off a debtor if it puts them below the minimum wage threshold. And lastly, insolvency. Insolvency can be done at any point in the debt recovery process, but I've put it here because it's most useful here, as once you've got a judgment secured against a debtor, this in itself is proof that they can't pay their debts. So in an insolvency process, the first step would be to send them and serve upon them a statutory demand. And when you serve the statutory demand, they have 21 days to defend or dispute the demand. Obviously, with you having a judgment against them, there isn't a dispute, as they cannot pay, as that is proof in itself that they can't pay the debts. Obviously, you can proceed on to a bankruptcy petition against an individual and a winding up petition against a company if circumstances allow and they don't respond to your statutory demand. But normally, the statutory demand in itself is enough. This is advantageous when the debtor, if you know that the debtor is financially well off, they've got a lot of assets and they can't afford to either go bankrupt or be wound up. So that was a quick overview of the debt recovery process, which hopefully helps you give you further insight into what happens if you pass a file to a solicitor. So I'm going to pass back to Michael now.
Thanks, Sadie. So just finally, in terms of recovering money that is owed to you, you need to look at this on a commercial basis and prepare yourself to ensure that you minimise any issues that there are. Prevention is always better than the cure. Thank you very much for joining us today. If you do have any questions, our contact details are on the slide. Myself, Stephen, John and Sadie will be happy to hear from you and answer any questions that you may have. Thank you very much.